Welcome back to PM Academy. Dear students, today's topic is appointment of Chief Election Commissioner and Election Commissioner of India. Now, this topic is a subject of discussion all over India by intellectuals because recently on March 2nd or 2nd March, Supreme Court gave a landmarking judgment relating to appointment of Chief Election Commissioner of India and Election Commissioner of India. Before coming to the topic, dear students, request you to like my channel, subscribe my channel and like my videos or share my videos. Now I am coming to the topic. 2nd March 2023, Supreme Court gave a very landmarking judgment that the Chief Election Commissioner of India and other two commissioners of Election Commission are to be appointed by a collegium system consisting of Prime Minister, Chief Justice of India and the leader of opposition parties. Now, dear students, why suddenly came the judgment? Now, I want to take you about the Constitution. When the Constitution was formed, it was clearly specified in the Article 324 that Parliament can or the President, Article 324 says the President can appoint election commissioners till the Parliament makes the laws. That means it was specified that originally in the Constitution of India, the selection procedures of the election commissioner was not there. Only it was specified that the Parliament has to make the law in the due course. Till that time, the President can appoint the election commissioner. Now, dear students, what happens? 75 years have passed off. So, lot of debate, discussions, suggestions have come to the government of India since independence for making or the appointment procedure of the Chief Election Commissioner of India and the other election commissioners. But till that, nothing has happened. So, when all these things were there, all of a sudden, the Supreme Court Constitutional Bench on the 2nd March 2023 gave a very landmarking judgment that the Chief Election Commissioner of India and other two commissioners are to be appointed by a collegium system, and collegium system consists of Prime Minister of India, Chief Justice of India and also the leader of opposition parties. If the leader of opposition party is not there, the leader of the largest party on the floor of the house, that will be the member of the collegium systems, and after the selection, after suggestions, it will be referred to the President of India, then the President has to appoint. Now, the landmarking judgment said that it is till the new law is made. Once the Parliament makes the laws, then the new procedure can be followed. Till that time, the landmarking judgment for the selection of the Chief Election Commissioner of India and other election commissions will prevail. Now, question arises, why for a long time it was not there? Though Article 324 was there, it prescribed that law to be made in the due course. Till that time, the President has to appoint the Chief Election Commissioner of India and other commissioners. Now, question of other commissioners. So, by the Act 1993, two new commissioners were appointed for balancing the election commissioner. Same thing happened because one person was appointed as the Chief Election Commissioner. Sometimes it was said that it is the bias or under the political pressure. That's why 3-member committee was made in the 1993 onwards. But still then, most of the cases, sometimes it is said some the political some political reflection is there, and there is no proper procedure for the appointment of the Chief Election Commissioner and the election commissioners. Now, when the Supreme Court gave the landmarking judgment, now question comes. There was no suggestions, there was no committee before. Yes, it was there. So, we can say for the last 50 years, a lot of attempts have been made by the government. Time to time, lot of committee have been formed. One, Justice Takunde Committee 1975. Second, Dinesh Goswami Committee 1990. Second, Administrative Reforms Commission 2007. Law Commission of India 2015, and all they have suggested means the appointment procedure should be framed by the Parliament for the appointment of the Election Commissioner of India, Chief Election Commissioner of India, and other commissioners. But till date, actually nothing has happened. So Supreme Court interfered. Supreme Court also gave a landmarking judgment in the constitutional bench, 5-judge constitutional bench on the March 2. Now it will be implemented till the new law is made. Now critics on the other side, what they say, they give another example of the Supreme Court's decisions 1973, that is you can say Goloknath and the states versus the state of Punjab and another. It is the 1973 matter. Supreme Court what said actually at that time? Constitution is the supreme. All the authorities, all the organs of the government has to function under the supreme law of the land. And also in this case, Supreme Court specified that power of the court is to judge the validity of the legislature or legislation itself, to judge the validity of the legislation itself. What the law is made by the Parliament, only it has to judge, to verify whether it is the right or the wrong, or it has not violated the basic structure of the constitutions. It is by the critics, those are opposing the Supreme Court verdict. In this way, dear students, the Supreme Court verdict also came, and no doubt as the time has changed, some procedure, some parameters should be framed by the Government of India for making or for the selections of the Chief Election Commissioner of India, because it is one of the tough offices to keep the democratic system in the proper. So no doubt it is, dear students, before concluding my lecture, request you to like, subscribe and share my videos, and very soon I will also come with a new topic, and this topic will highly helpful for you the civil service exam. Thank you today, dear students.